Just when you thought it was safe to go back in the water, I guess we're still going.
Received an email um, that the person sending the email had found a post on Justice for Darrell on Reddit. So it's a subreddit. I'm not familiar with how Reddit works, but and that the thread on the Justice for Darrell Reddit site was claiming to be a member of the jury pool. And
Oh.
I am going to provide the parties with the information that I was given this morning. It's a color copy of the attachment and the email that was sent. The email was received by the clerk of court at 9:10 a.m.
You gotta be fucking kidding me.
Then my clerk received a notification at 9:30 a.m. that the clerk of court wanted to speak with me. You may recall this morning I stepped off the bench for a little bit of time. I read through the information that was provided to me, which was an email, and then the attachment, which is a
The prosecution is laughing. Probably not a good sign.
color print off. Looks like the person took a screenshot, and that the anonymous post claimed to be a member of the jury on the case, and here are my thoughts on the trial and on this subreddit. And apparently, again, it's a subreddit called Justice for Darrell. All those, Justice, the number 4, and Darrell, all, no spaces. I then had contact with
I think they're gonna quash this.
Captain Dussault, advised him that the
I see what you mean by saying that it's not good, because it creates more like disruption or static, I guess, in the case. But the reality is, I think that this is going to get quashed pretty easily. It's going to be like it's it's like Trump supporters, their subreddits get shut down pretty quick.
this should be investigated, and basically turned over the matter to law enforcement for a full investigation. At this point, or at that point, I made a determination based upon my review of the information that I would not stop what was happening in terms of the trial with the instructions to the jury and ultimately the closing arguments, and then turning the case over to
Don't stop,
the
girlfriend.
jury for deliberations.
Hot judge for the win.
And of course, I am concerned about the integrity of these proceedings, and I will take whatever action that I deem appropriate once a full investigation is done. But at this point, there is no, I would say, credible information
No credible information.
that this is in fact a member of the jury.
Uh-huh.
But I will leave that for law enforcement to determine, and of course, if need be, at the conclusion of the case, when the jury reaches a verdict, I certainly will consider whether any questioning of the jurors at that point is warranted. So that's the information I wanted to provide. Again,
doesn't
copies of this
surprise.
information will be provided to the parties, and there is a full investigation underway by the Sheriff's Department. I have no further information about it at this time. I will not be the judge that will further be reviewing it in terms of any requests related to that investigation. I will simply be handling whether any requests as it relates to this case in particular.
This case.
And I hope we
God
have the
damn it.
copies for the parties.
Your
And we'll
Honor,
provide those. Go ahead.
I'm making sure you was
Go
done
ahead.
first. What is this?
All I can tell you, sir, is that there is apparently on the internet, on a site.
Hang on. This is an act. He acts like he does not know what's going on. Dude, this is interrogation 101. I don't know what you're talking about. What is this? What are you talking about? But he has no real actual reaction. He seems very calm, peaceful. Look at the eyebrows. Yeah. I'm on to you, BB.
or maybe it's an application, I'm not entirely sure, called Reddit. There's a subreddit that is entitled Justice for Darrell, and it was on that subreddit that someone wrote an anonymous post claiming to be one of the jurors. That, of course, would be a violation of the rules that I set up for the jurors, which is why I turned over the information to law enforcement so they could make a full and complete investigation.
For the record, I accept for value and return for value these documents.
All right, he's scratching his head. This is I was not expecting this, but you already knew what was going on, but you did not expect the reaction. I'm not a body language expert, but I'm not bad.
I'm confused.
At this point, sir, I'm providing the information.
I'm gonna say again, you've shown confused throughout the entire trial. You've shown a baseline for your reaction to confused as you present it. Look, there's no wrinkles in his forehead. He's not confused at all. He's not confused at all.
I trust that the parties will review it, and if a party believes that any request needs to be made of this court, then an appropriate request will be made. But at this point, I'm just advising the parties of the information that I have. And I will add this, I will, of course, it's important that the results of any investigation be turned over to the parties. I don't know how long that will take, but that is also my direction. That was really the only direction I gave to law enforcement, is that the results of the investigation that be turned over to the parties.
Was this? Oh, I'm sorry.
Go ahead.
Was this just found out about this morning?
Yes, the email that was sent to the clerk of court was received at 9:10 a.m. And then that email and the attachment, I'm aware of a second, I will say I'm aware of a second email that was.
I'm gonna go back to his baseline. When he's confused or surprised about something, this is not the way that he acts.
Was this just found out about this morning?
Look, 0 lines on the forehead. Very, very straight line, confident. He knows what he's talking about. He's heard this before, and he's prepared for this line of questioning.
Yes, the email that was sent.
In fact, every time that every time he thinks he's got something on somebody, he does the whole act, the whole thing, the whole reaction, his actual reaction, where he's like, Right now, he's got a calm, composed. He's not surprised about this information at all.
To the clerk of court was received at 9:10 a.m. And then that email and the attachment, I'm aware of a second, I will say I'm aware of a second email that was sent to our clerk of court at 10:02 a.m. And I think when we stepped off the bench following the case being given to the jury, I was advised that other emails had been received throughout the court system, and I simply said, obviously that information needs to go to law enforcement. I haven't seen it, haven't reviewed it, but any email will go to a forensic unit.
I've also received similar emails at my office this afternoon. They were sent not to me directly, but to the district attorney's office website. And I only wanted to point out that in viewing the contents of the posting, well, first of all the emails refer to the exact same posting and the language is the exact same in all the postings. In viewing the content of the posting, we question the veracity of the posting because it refers to things that, quite frankly, are not true. And upon reviewing it, Your Honor, we came to the conclusion that it does not exhibit any material prejudice against Darrell Brooks that may affect the veracity of any verdict that may be returned in this case. The posting is largely critical of the court and to some extent the prosecution, but the nature of the posting is actually in support of Mr. Brooks. That's why it's under a subreddit called Justice for Darrell. And I don't believe there's any reasonable reading of this post that would lead someone to believe that it suggests the juror harbors substantial or material prejudice against the defendant.
Thank you, I appreciate the additional record.
Like,
Can I
even
say something, Your
though,
Honor?
Go ahead.
even though you tried to sow discord, the prosecution was smart enough to prove that your attempt at sowing discord through whatever means you went through. Whoever you talked to, that, oh, I'll make a Reddit post and we'll get a whole thing. Oh yeah, yeah. Or on the other side of the glass, yeah. We're gonna do that. Just you gotta get me. You gotta pretend we're. You gotta do something to delay my case. Come on, we're gonna do it. And the prosecution actually said, you know what? That actually doesn't. That doesn't discount our juror.
Just briefly skimming through it.
Which you don't even. Wait. He has never briefly skimmed through anything with any material representation from what he learned, from what he skimmed over. I'm going to say again, he already knows what he's about to say.
Do want to state for the record that I have no involvement with this. Really like shocked like this even came to light.
Wait, did anybody indicate that you had any involvement in this? Again, interrogation 101, dude, sorry. You lose again. And hard.
I will say
Now he's gonna give credit to something that's in the document. Well, that's true.
just by skimming through it, these are definitely things that have been talked about in the court. So
Look, zero surprise on his face. Dude, his head wrinkles real bad when he goes. None. He knows exactly what's happening.
common sense would say that this came from someone that has either been in the court to hear what goes on in the court or a jury member. This is no other way.
Well, actually, the proceedings are live streamed worldwide, Your Honor, available on YouTube worldwide, so I don't agree with that assessment.
Look at the process.
Well, it's pretty obvious that this would come from somebody who's actually.
Yeah, you.
I think it's pretty clear.
Well, I'm leaving it in the hands of law enforcement to do a full and complete investigation. Again, I take the integrity of this process incredibly seriously. And if there were to be a juror who violated the rules, I would take that very seriously, and I will not hesitate to take any action that I deem appropriate. At this time, it is simply being investigated. This was an anonymous post, and if either party believes any further action needs to take place as it relates to this particular jury, then I trust they'll file the appropriate request with the court. So with that, the courtroom, go ahead, I'm sorry. Something else, Attorney
A
Alper?
different topic, Your Honor,
Oh,
if
sure, go
possible.
ahead.
While we're all together, I just wanted to address exhibits and what the court's procedure would be. We have no objection to any exhibits going back to the jury room if they are asked for. We
Actually,
Do you have any
Chair.
position on that, sir?
Yeah, I would object from the standpoint that I would need to see any exhibit that's being asked about and the relevancy of that exhibit being asked for. I
We're
think that's
past
only fair.
this, dude. We're way
Exhibits
past
that
this.
have been received, a relevance objection, would no longer be valid because the court has already ruled on
The
the
jury
relevance
is
and the
already
admission of the
deliberating,
exhibits. The
you
issue is whether it goes
jackass.
back to the jury room. I'll give you for example. Sometimes in a trial there are medical records that need to be filed in their complete form under the statute, but really maybe only a portion of it would go back to the jury, or depending on why they were offered and whether there was any medical testimony regarding a diagnosis, for example, could impact that. Sometimes there's privacy issues with an exhibit, if there's a social security number for a witness or something like that. But generally speaking, the exhibits have been received, and the jurors can ask to view photographs, written documents. They can even ask to view the videos. The videos would need to be done one of two ways, either which requires everyone to assemble because we do have the technology to play them directly to the jury room, but that simultaneous with that is going to be played in here. So everyone would be seeing what's being played in the jury room at the same time, so that does require the parties to be in court. That allows the jury to continue with their deliberations, talk about what they're seeing, etc.
So can the jury see in here now?
No, I'm talking about a video. We have the ability to play it directly. There's a TV.
Dude,
I
you're
should
a
have said
fucking
that.
idiot.
Probably not. That here could be a still photograph, could be a document, could be a video. We can play as far as other exhibits.
So
Correct.
nothing new, nothing's gonna come out of the blue and be like, yo, yeah, we're gonna.
Only what's been received during the trial. If it would be helpful, I can have Madam Clerk give you the printout of the exhibit list that shows everything that's been received, if you would like.
That's about like 7,500.
There's a lot of exhibits,
That's a
but
lot of exhibits.
but I'm willing to have her print it off if you would like it.
I think it'd be helpful just in case.
Yeah.
I'm guessing at some point that will come into play.
Right. For example, they may come back and say, we'd
At
like to see
some
exhibit
point,
15,
the
which is
jury
the map.
is
The large
deliberating.
map of the parade route, okay? They might want to see the other map. Maybe they want to look at a video. There's a lot of exhibits, so I'm not going to speculate what they want. Sometimes they write notes to us and say they literally list out all the exhibits that they want. Other times they'll say, can we have all the exhibits? So sometimes parties do stipulate. That's what the state, I think, was trying to get at. So do you have a position on that? If the jury requests an exhibit, do you want the court to rule on it individually, or do you agree that if they request an exhibit, it can be released to them?
A rule on it.
All right, fair enough. Anything else, Attorney Opper?
Yes, we had discussed yesterday, and I'm not trying to get too far ahead of myself here, but what was the time limit that the court wanted to work off of for giving notice to the parties when the verdict is available?
30 to 60 minutes.
Okay. Thank you.
Some of that will depend on when it is, if it's
Yep.
late in the evening versus during the day. And you might be wondering how late will I
When
let them go
verdict
tonight?
is
Honestly,
available.
they've been at our schedule for 3 weeks. I will let them dictate how late they want to go tonight. When they tell me that we're done for the evening, they'll come back in. I'll read them the instruction about, they obviously can't deliberate when they're not here, so I'll read through that instruction to them that you can't deliberate. And they would go, again, where they are being sequestered, and then we would reassemble tomorrow morning if that's what is needed.
Okay. Thank you.
You're welcome. Anything else from you, sir?
Did you talk to the jail, the deputies? Or
I did. Thank you for that reminder. The jail has asked that I follow the standard operating procedure, which is to have you in central holding and not up at your cell. But if need be, I'm willing to order that they give you a shower later, if that's helpful, whether it be tonight or tomorrow morning, okay? So even though you're gonna stay close by, I'll work with the jail to make sure that you're given that opportunity after we're done for the night, okay?
Yeah, at least let me take a shower.
So I've been
Then I will
told
have to-
there is a question that will be coming out shortly, so don't go anywhere.
Don't choke me, Judge.
What?
I said, don't choke me.
Choke you?
Yeah, because you know what I'm about to say.
What are you about to say?
Subject matter jurisdiction. You knew I was about to say that.
Sir, I'm not gonna address it, I already have. All right, there are requests for 3 exhibit. Is that his number? I know he signed up, but I do. I meant to tell them that. It's a signature. I need to know the number to tell the parties who the 4th person is, because I'm not gonna say the name on the record. They have a request for 3 exhibits, 15, 5, and 55. Number 11 is the 4th person.
You said 15, 5, and
55. So I can pull.
I was gonna say I don't know. I know 15.
15 is the map.
15 is the map. Yeah.
Any objection to the map, sir?
Yeah. I want you to rule on everything.
Well, I was gonna go one by one. So I'll start with exhibit 15, which is the map. What's your position on that, sir?
My position is at this point, what is the relevancy of the map? I think it's been seen a million times. I know about heart now. That's probably the only one I know about heart.
Well, what's the
You were
state's
there. You were driving.
Yes,
You were
absolutely.
running the
There's
people
no
over.
reason not to
You
send that back.
jackass.
There's 76 counts that they need to work through, and to assist them in identifying which victim is which and which group they were with and where they were on the road. Absolutely, there's no reason to hide that from them. It's helpful to them in their deliberation.
All right, I will send exhibit 15 back to the jury room. It is an exhibit. And there really is no reason not to send it back that has been identified by the parties. All right, the next exhibit is exhibit 5. That is the photograph of Erica Patterson.
Oh, I definitely object to that. Seeing as how it was supposedly 2 incidents, one of which didn't even happen, which
2 incidents,
prosecution
one of which didn't even happen.
sent paperwork to acknowledge that it never happened. So I don't even. It's too dicey with that. What incident would 5 be referring to? One of which
The
never
battery
happened,
count.
and then one. I don't even know what I'm looking at if I look at 5.
Yeah, I know. It's not going your way, buddy. Bye.
What's the state's position on 5?
Again, Judge, there's no legal basis to exclude that from the jury. There's nothing prejudicial. It's a single photograph, I should say overly prejudicial. It's a single photograph of a single person showing the injuries that are alleged to be associated with count 77. It's directly relevant to their deliberations.
There is no count 77.
Count 76. You are correct. It is count 76, not 77.
See why I'm confused?
Well, there is an amended information, and I clearly instruct the jury on 76 counts. Be that as it may, I'll find that it is proper for Exhibit 5 to go back to the jury, and that will be sent to them. Now, Exhibit 55 is a video.
You're like, oh, the jury already has a verdict. Actually, they're probably gonna milk it for one more day.
15
They're like, fuck it, we've already, we're here. We're
So
sequestered.
my inclination, and I'll hear from the parties
Cheers.
first, and then I'll give you my
Great.
inclination. So, any
Tomorrow
objection to
morning, we all
playing
know
for the
he's
jury
fucking
Exhibit
guilty.
55?
Yeah, we all know.
What exactly is in the Exhibit 55? I don't.
It's a video from Curry Insurance facing eastbound showing the grannies being struck.
The
We can put it up
grannies
if you want to
being
preview it, Your Honor.
Go ahead.
And we are requesting that it be viewed by the jury in their deliberation room.
What I can tell you, if I do allow it, since I would have to, we'll verify that the technology is working, and then I would play it for them twice through.
twice.
And we would watch it at the same time as they're viewing it. Theirs would just be in the jury room. But I'll preview it for Mr. Brooks so he can see it first. Well, the state will preview it for me.
You ain't go nowhere, bitch. You dead.
All right, your response, sir?
Yeah, of course he's gonna.
Yeah, I object to it. It's in order.
Come on. Come
I
on,
guess my
buddy.
objection would be
Ground.
well, it would be hard. It would be hard to say why the jury would request it.
No, that's not natural. They've already.
I don't know. I'll just let you rule on it. I don't
Yeah. Yeah.
particularly.
You just sit down and shut the fuck up. You're done, dude.
There's so many videos that's kind of like the same video anyway.
Well, Exhibit 55 was received by the court. It's relevant to the charges in this case, and I will show it to the jury. I will work with Teresa and then the jury bailiff to ensure that the technology is working when it's up and running. I will play that for them twice through. This is what I have proposed to write on the note back to the jury as it relates to all three. Exhibits 15 and 5 are attached. Exhibit 55 will be played for the jury 2 times, hyphen the clip is 15 seconds. And then I will initial that and date it.
Any reason why it would need to be played twice?
And I just would note that the jury foreperson wrote yesterday's date. It is the 25th. My date will be indicated. Obviously, they didn't get the case until today, so it's just a Scrivener's error on their part, putting the 24th versus the 25th. They don't have their technology with them, so I can't really fault them for that. All right.
Any
Madam
reason
Clerk,
why
if
it
you
need to be played twice?
that's my practice, at least on short video clips. Copy
So
this
what about
first.
what about if they request for a long video?
Then I'll make a determination then. I find that since we have the new technology, it's easier just to do that and play it twice than to bring them out and for them to say, stop, and then can you go back and can we watch it again? Because that's my experience. So I'm really trying to avoid that. So we'll stay out here, and then we'll work to, they'll have to pause their deliberations so we can interrupt them and give them the exhibits and then make sure the technology is working. So if the state wants to have that ready to go.
I set for value and return for value these documents, Sharon.
Thank you.
Gotta do this determination. Ground.
Do you have, you know how to do that, right? We've done that before.
It's one button. It's SCG 003. It's pretty straightforward. Is Jen ready for me to change it on?
John Wayne said, "Life is hard. It's harder when you're stupid."
Is there, audio with this or is it just video?
Just video.
Okay, thank you.
H.
That's, do you have the email that has the 910? Exhibit 55 at 40% speed. Obviously, I don't recall specifically if this video was shown at a reduced speed, but many of the videos were shown at reduced speed during the trial. That was allowed. I think it's proper to also show a video clip to the jurors if they request it at reduced speed. So I'll grant the request.
What would be the significance?
The significance is the jury's requesting it, sir.
I'm saying at that speed.
That's their request. I can't tell you the significance for them. I don't want to speculate. But I think it's proper, given the technology that we have available and what was done during the trial. So I will allow it.
So why even ask me if I have a position?
Because that's what I'm required to do, sir.
But you're not required to address subject matter jurisdiction, which hasn't been proven for the record.
I can do
I'm
that.
not allowed to answer any questions I ask. Your name,
Mr. Brooks, I'm not going to relitigate your case right now.
I mean,
And I've made my decision on subject matter jurisdiction, so your request that I address it once again is denied.
of course it's denied. Of course, because you can't prove it on record. I mean, come on now.
I wanted to make sure.
It has yet to be proven. It has to be proven at some point. Or do I gotta go through the song and dance to get it proved?
Are you ready?
You're
When they are.
Jury's ready?
jury's ready.
Once or twice.
Just once.
Oh, please, God, let this be you. Yes. Yes. Yes.
That's 40% speed?
Oh. Damn it.
Yay, nay.
I thought it was the end of jury deliberations. Got excited.
The video clip is now ended with the state just confirmed the speed at which it was just played.
Yes, 40%, Your Honor.
Thank you. All right, then, if there's another question, the court's gonna step off, obviously will remain open.
What the hell is that noise? That might be the end of our broadcast for this evening. It seems that way. Boy, they went late today. They are really trying to get this shit over. I don't blame them. Fuck this guy. All right. Well, thanks for hanging out, guys. We'll see. Catch you next time.